Good morning. My name is Elijah Larson, and I'm very happy to be here. I am an attorney at Employer Lawyer, and today we're going to go over our topic, which is it okay for employees to complain about their boss? Specifically talking about employee complaints and the NLRB. Just a little background about myself. I'm originally from Farmington, New Mexico. I attended Brigham Young University, Idaho, for my undergraduate, and I went to Brigham Young University for my Juris Doctor degree. I'm licensed in both Utah and New Mexico, and I've worked here at Employer Lawyer since April 2025. As a general disclaimer, this is only general education only, and this doesn't constitute legal advice. There is no attorney-client relationship created by attending this relationship, and employment laws vary and change, so it's always extremely important to consult with legal counsel about your specific situation, which you'll hear me talk about a little bit today. So before you take this to the bank, make sure to call us to make sure your specific situation is in line with what we're talking about today. To start, one of the biggest misconceptions that I see working with businesses is at will employment. All of these phrases are phrases that I imagine you've heard or at least thought of at some time. We can fire you for any reason or no reason. If you don't like it, then you should leave. We don't need cause. Nobody forced you to work here. It's an at will state, or it's not just a good fit. This is true. It is an at-will state. At-will means that you can fire anyone for anything for any legal reason, right? So if somebody's performance isn't up to par, and that's the reason why we're firing them. Or a great example is being from New Mexico, I wear bolo ties. If I come into work and Spencer Phelps, my boss, says I'm just not a fan of bolo ties, he has every right to fire me for that, right? As long as it's not related to my ethnicity or my race or the country that I'm from. In this specific situation, it wouldn't be any of those, so it'd be totally good to fire me because he doesn't like bolo ties. But when is it not a trump card or a golden card or the Uno reverse card at will employment? Well, I think that businesses are pretty good at knowing when a situation presents risks under discrimination statutes like Title VII, which is the race, ethnicity, gender, sex, those types of discrimination, and the Americans with Disability Act, the ADA, which is disability discrimination. But many employers are a lot less experienced at identifying risks that are associated with other employment laws, like the NLRA. So today we're just going to do a brief dive into what the NLRA is and what you need to know as business owners so you avoid falling into any pitfalls. The National Labor Relations Act, or the NLRA, is a federal law that protects employees' right to join together to improve their wages, hours, and working conditions. And they can do it with or without a union. The NLRA gives employees the right to discuss workplace issues, support or oppose a union, engage in group complaints, or organize, bargain collectively through a representative, or refrain from those activities. The National Labor Relations Board, or the NLRB, is the federal agency that enforces the NLRA and investigates unfair labor practice charges involving employers and unions. This is a law that comes from a different time of our country where collective bargaining was probably more prominent than it is now, and typically people think that this only applies to big businesses. And sadly, that's just not true. Um, to have jurisdiction, the National Labor Relations Board has you evaluates whether or not you meet any of four qualifications. These qualifications are that the employer is a private sector employer whose business affects interstate commerce, which is virtually everyone. The employer meets the NLRB's applicable jurisdiction dollar volume standard, which depends on the industry. But just to give you some examples, for retail businesses, if they're generally covered if they have at least $500,000 in gross business volume. In non-retail businesses, it's generally covered if their annual interstate flow or outflow of goods, so inflow or outflow, is valued at least $50,000. So the bar is extremely low for an individual for the dollar volume to to be covered. The workers involved are covered employees under the NLRA, so they're not management. And the dispute involves rights protected by the NLRA, such as union activity, collective bargaining, or protected concerted activity, which is something we'll talk about later, about wages, hours, or working conditions. So, really, the likelihood is that the NLRA probably applies to your small business. So, let's talk a little bit more about what's protected. So, the National Labor Relations Act protects, as we talked about, most private sector employees and their right to act together to improve wages, hours, benefits, safety, schedule, policies, discipline, supervision, other working conditions. This protection applies, as we've said before, in both union and non-union workplaces. Um, the employees do not have to be part of a union or even try to unionize to have NLRA rights. And some of these protections that we've talked about briefly are discussing wages, benefits, schedules, or working conditions, discussing or supporting union, complaining together about a supervisor, policy, workload, pay practice, or safety issue, raising concerns on behalf of coworkers, speaking to government agencies about workplace concerns, or circulating a petition. So the key word is concerted activity. Employees are protected in when they engage in protected concerted activity. Concerted activity is defined by the NLRA, means when two or more employees are acting together to induce group action or to bring about change. Importantly, though, and this is where most of the businesses that we know get surprised by the law, one employee can also be protective if they're speaking up on behalf of their coworkers, bringing a group complaint, trying to start group action, or preparing for group action. If an employee can show that they're engaged in this concerted activity, then they're likely protected by the NLRA. So what happens, what's the process like for an NLRA complaint? Let's say we have an employee who was complaining about their boss constantly and they got fired and they believe that their NLRA rights were implicated. Well, so they usually fire an unfair labor practice charge with the National Labor Relations Board. The deadline or the statute of limitations for them to do this is generally 6 months from the unlawful conduct. The NLRB investigates it through their regional office, and then investigators may interview witnesses, request documents, and take affidavits. Um, if the NLRB thinks that there's merit to the case, they're going to try to settle it. And then if there is no settlement, they'll issue a formal complaint and go to an administrative hearing. Um, and as a side note, we can't retaliate or for filing or participating in the NLRB process. Importantly, this process can take a long time. We've had cases that we've worked here at the office that have taken years. And during that time, one of the critical things is an employee can be entitled to back pay if they are found to have had their rights violated. As a result, we've had cases that have settled for extremely high dollar amounts because the back pay had accrued quite a bit. And by no fault of our own or the fault of the client, the NLRB had taken a significant amount of time to actually get through the case. Like many federal agencies, they're slower than molasses at really cutting through and getting these things completed, and that's likely just due to their workload. The process is very similar to the EEOC and the Utah Labor Commission's process, where businesses are required to respond with a statement of position or a statement that explains all of the facts of the situation and why they didn't believe that they had discriminated or retaliated, or in this case, violated the National Labor Relation Act in the way that they disciplined or spoke to the employee. Um, it's costly. It's a costly thing to have us write a statement of position and to defend against these. So the best thing for businesses to do is to avoid the problems from the very beginning. And that's why, one benefit of our firm is that we try to help our clients really solve problems before they become problems so that they're saving. And when those problems come, we are first enough and have experience doing this to the point where we can do it as efficiently and as cost effectively as possible while still protecting the business. So within the last 6 months, we have seen an unprecedented amount of NLRB related matters in our office. These are some of the big areas that we've seen: being terminated or disciplined for disclosing wages or encouraging others to talk about their wages, complaining about quotas, and complaining about treatment from management. All three of these areas are things that are easily overlooked and seen as falling into that at-will employment. Talking about wages, a big part about the NLRA is that individuals can disclose wages and can talk about their wages with others. Any company policy that says you will not disclose your wages to other employees is likely going to be seen as unlawful. So that's something that we would avoid altogether. I recently have worked on 2 cases where this was an issue. In one case, an individual recorded their boss telling them that they were in trouble for disclosing wages, and they filed an NLRB complaint. So the business is in a difficult situation now, trying to run or change the facts of that situation or paint it in a good light because the employee has a recording of their employer telling them that they don't know if they could trust him anymore, and then they got fired a couple weeks later for talking about wages. Another is an agreement where we saw where a company sent out an agreement to their employees and wrote, there will be consequences for discussing this agreement. Those are both violations of the NLRA, more likely than not, and there are situations that companies trying to keep private information private so as not to offend people can really get themselves into trouble. So complaining about quotas. This goes into the workplace conditions. Companies have the ability to truthfully determine expectations. But when an employee on behalf of themselves or other employees start advocating for better protections and more change, then companies need to be a little bit more wary about either retaliating against them or immediately terminating them. So those are some things we've seen later. And then the last is just complaining about general treatment from management. As we've seen before, and as I've talked a little bit about, complaining about your supervisor typically is something that's seen as completely at will, and it usually is. You don't have a right just to complain that your boss is terrible, but when you start doing it on behalf of other people and on behalf of the team, that's where things change a little bit. Um, AI has completely changed the shape and the scope of NLRB complaints, in our opinion. Within this document, you can see before helping with this webinar today, I plugged into ChatGPT. I work at a company and I hate it. I complain all the time about management. How can I make this into a legal claim and get a big severance for my company? As you look, chat first tries to defend itself, saying they're not going to help me manufacture a legal claim, but then they give possible theories. If you look at that fourth theory, the fifth theory, forgive me, it says protected concerted activity. You complained with or behalf of coworkers about wages or working conditions. The NLRB even says even one employee may be protected when bringing group complaints, trying to induce group action, or preparing for group action. This is critical. I just had a case come into my door a couple weeks ago where an individual was writing group complaints or writing a complaint with other members of their team and submitting it to management. And that's likely, and they're fired as a result within a couple days. That is likely protected activity, and that individual likely has a claim against the company for violation under the NLRA. So, with the new era of AI and the changes in technology, these are how I've seen employees manufacture complaints in situations where there really wasn't group action, but AI has kind of helped them. First is using ChatGPT to write team complaints. In one case I recently worked on, we even found the chat logs showing the employee that they use on their work computer, showing how the employee was asking chat to help them make their complaint fall into line with group action and make it protected under the NLRA. So that's hard. It's a hard thing that businesses are starting to deal with, and so now they need to be really wary. Some words to look out for is when an employee makes a complaint or is complaining about management and they're using words like we or everyone. Um, Another thing is copying coworkers on emails to make the issue appear group-based, raising pay, workload, or policy complaints after discipline begins. That might be an indication that either they're looking to see if they can't leverage their situation based off of the NLRA or trying to invoke NLRA protections, and then framing performance and discipline as retaliation for speaking up. Um, that's also likely NLRA related.
What can men do against such reckless hate?
So, changing King Theoden from Lord of the Rings words here, what can businesses do against NLRA complaints or against the potential of having NLRA complaints? Well, the answer is always the same if you talk to employer lawyer. And the first answer is to document, document, document. When a struggling employee begins complaining about workplace conditions, that's when the employer should start to proceed carefully. The key is to continue documenting their legitimate performance concerns while also documenting the company's good faith response to the employee's complaints. Not only do you need to document what the employee's shortcomings, because in all actuality, it's rarely the employees that are doing well that are making these complaints. It's individuals who are already struggling, already having problems with the company, already have an inkling that they're going to be ousted. The company needs to not only document this, but also document their efforts to make sure that the employee is being worked with when discussing their NLRA related complaints or when bringing up group activity, and to show that they weren't retaliated against, that the HR took the time to do an investigation, that HR took the time to hear them, to discuss about how they could improve and make actions to potentially show that there was improvements made. And that's the most important thing for businesses to do to be able to show that it isn't just an NLRA issue, but instead it's a legitimate performance issue that the employee is trying to repicture as an NLRA complaint. The biggest thing I would say is before you fire, you got to hire us. And just let us do a quick review of your situation to evaluate whether or not there's a certain risk in terminating certain problematic employees. Allowing us to evaluate whether a situation has enough documentation where you'd be better situation if they make a complaint to the NLRB is helpful in one, knowing risk and evaluating whether or not this is risk. Another thing is to have us look to see whether or not this is the type of issue that a severance agreement could be helpful in just ensuring that the company's not going to have any risk going forward with the employee and making sure that the employee waives all their claims so that we're not having to deal with this in the future. Those are all things that we do and we're happy to do, and we encourage you to reach out to an attorney before you decide to fire these individuals that are engaging in this activity, just to make sure that your business is protected from a long and drawn out and potentially expensive process if it's going on for years with the NLRB. Now, it's important to talk about what's not protected and under the NLRA. And just like at the beginning with the at-will golden ticket, for employees, this isn't a get out of jail free card to avoid termination. Purely personal gripes with no connection to coworkers or group workplace concerns are not protected. Complaints that are made only for the individual's benefit or saying, I'm treated badly, I don't get this, I feel like I should get that. None of that's protected under the NLRA. Refusal to follow lawful workplace rules is not protected under the NLRA. What could be protected, like we've said before, is when the employees advocating for changes on behalf of their coworkers or with their coworkers. That is where it could turn into protected activity. But just refusing to do their job isn't going to be protected under the NLRA unless it's an unsafe or they are invoking business related things. And when I say unsafe, I don't just mean like they don't feel safe. I mean legitimately unsafe and that they're doing it on behalf of other coworkers. As always, you should talk to an attorney before you make any decisions. but these are just general things that are not protected in the NLRA. Public attacks on the company's products or services that are unrelated to a labor dispute. If they're telling customers, yeah, this company's terrible, I don't want to work here, you shouldn't buy from us, that's not protected. Or being harassive, discriminatory, or engaging in egregiously offensive conduct. If they cuss out a manager, if they if they're engaging in just discriminatory behavior or harassing other employees, they're not going to be protected under the NLRA. It's not a get out of jail free card. And then finally, the key takeaways is ChatGPT, Claude, all these other AIs have fundamentally changed the way that the workplace and disputes in the workplace are occurring. Many employees are putting in their complaints into chat before they send to the management. Sometimes, whether intentional or unintentional, ChatGPT is changing the wording to make it stronger for the employee. And in doing that, they're potentially imbuing NLRA protections on it. And we've seen that at our office, and we've started to have to deal with the realities. So the key takeaway of this is employees can't complain about their boss as an individual or say that they hate their boss or speak negatively of their boss in a discriminatory or harassing manner. But what employees can do and what they are protected in is banding together to change workplace conditions. And importantly, one employee can do that by themselves if they're doing it in the right way. And with the modern age of AI, that's becoming easier and easier for employees to do, even inadvertently, and to discover after the fact that they've engaged in protected concerted activity. So it's important that before potentially firing an employee, that you reach out and let us know um, if that employee's been complaining and have us evaluate whether or not there is any risk there. And if there is, we'll help you through it. We'll help you proceed in the best way forward and minimize that risk or even eliminate it if we can. Um, but with the new age of AI, we also need to adapt both as attorneys and as business owners and better equip our clients to deal with these realities. So if there's any questions, I'm happy to answer them. But if not, I thank you guys for the opportunity I have to just explain a little bit about the NLRA.
If there's any questions, you're welcome to throw them in the Q&A chat at the bottom of your screen, but if not, we can wrap up. Well, I think we're all good, Elijah. Thank you.
Okay, thank you. Have a great day.